Hi, I'm Aidman, and in today's video we're going to discuss discovery motions. So the first thing you need to understand is what discovery is. Discovery is the opportunity that each side has in litigation to discover what the other side's case is all about. So it starts with written questions and requests for documents, proceeds to depositions, which is sworn question and answer, lawyers asking questions of opposing client, and medical examinations in the insurance company. There are other things, but those are the main categories. Now, what happens a lot of times is the sides don't cooperate. And so one side or both has to ask the court to intervene, to enter orders compelling the other side to answer interrogatories, produce documents that it refuses to produce a client for deposition, or maybe there's a dispute that arose at the deposition. They got to bring the client back because the lawyer prevented his client from answering a proper question. A lot of times discovery motions are simply that the other side hasn't responded to the written questions or the request for documents, and typically each side has 30 days to provide answers and documents, and if they don't, and a lot of times they don't just because they are too busy, or they feel like, let's see if the other lawyer knows how to file a discovery motion or will file a discovery motion, because if the motion isn't filed, you don't have to produce the documents or the answers. So a lot of times it's just, I got to go ahead and file the motion because the other side is just ignoring my request for information. It happens all the time. Once you file the motion, they produce it. They don't necessarily produce everything. They don't necessarily answer everything completely. In fact, mostly they don't. One of the rules that we use in providing discovery to the other side is to do no harm. So I want to answer honestly, but I don't necessarily want to be extremely detailed in how I answer questions, because I don't want to create room for inconsistencies to creep in. If we answer interrogatories in one way, and then at deposition the client testifies another way, then you've created a credibility issue. So a lot of times answering interrogatories is something that's done in a pretty summary fashion. I'll try to get into this more in future videos. There's a lot more to it, but that's a basic introduction.